Now, the hearing of the 14 petitions challenging the Finance Act 2023 will take place next month. While making the ruling today during the mention of the case, a three-judge bench led by Judge David Majanja have said all petitions have been consolidated and will be heard together. At the same time, the High Court has declined to suspend section of the Finance Act. And as Alice Diana reports, the bench also struck out an application in which Busia Senator Okiya Omtata was seeking to cross-examine the National Assembly Speaker Moses Wetangula and his Senate counterpart Amason Kingi.
The three-judge bench appointed by Chief Justice Martha Koome last month is set to start hearing all the petitions challenging the implementation of the Finance Act 2023 from the 13th and 14th of next month. In their ruling on Monday, Justices David Majanja, Christine Meoli and Lawrence Mugambi have directed petitioners who wish to amend their petitions to do so by Thursday this week.
All the petitions listed before us today are now consolidated for purposes of hearing. We'll hear them all together. Number two, any petitioner in any of the respective petitions who wishes to amend their petitions may do so, to file and serve their respective petitions by 10th of August 2023. By 10th of August 2023. Then the respondents and interested parties to file and serve their replying affidavits within 7 days from that date, and they should do so by 17th of August 2023.
During the mentioning of the case at Milimani Law Courts, the Law Society of Kenya LSK also sought orders to suspend the implementation of the Finance Act 2023, urging the court to declare the Act's implementation as illegal and null.
And my Lord, we seek that the court does grant a conservatory order against the implementation of Section 31B and 31C of the Employment Act as introduced by Section 84 of the Finance Act.
The three-judge bench led by Justice Majanja, however, declined to give rulings on applications seeking to suspend sections of the Act until the main petitions are heard.
Although the court stated that the court could consider suspending specific provisions of the Act whose implementation would have an irreversible effect, and where parties cannot be refunded, we are not persuaded that we should exercise this jurisdiction at this stage in view of the fact that these issues were all before the court when it made the decision. Must be recalled that this is a decision in rem, and it binds all the parties whether they were before the court or not. So that the petitions are now scheduled for hearing, and it is on that basis that we decline to give any interim orders, because we believe those matters of conservatory orders were resolved by the Court of Appeal. And all the issues raised may still be canvassed in the parties' pleadings and submissions. Those are our orders.
Earlier, the High Court declined to grant orders to summon Speakers Moses Wetangula and Amason Kingi for cross-examination. The application by Busia Senator Okiya Omtata had challenged the legality of the new tax measures, arguing the bill did not pass through the Senate as required of laws that touch on counties.
We need to cross-examine him on the facts he has in that affidavit, because the affidavit is fundamental to determining one question: whether or not there was concurrence between the two speakers of Parliament on whether the Finance Bill 2023 was a bill concerning counties as described in Article 110, Clause 1 of the Constitution of Kenya 2010.
Lawyers acting for both Wetangula and Kingi, however, opposed the application, which the bench dismissed.
In terms of the issue of concurrence, these are issues that can be dealt with in the main petition. They do not require for the speaker to be cross-examined. So really, as far as I'm concerned, the PU also raises the issue of the fact that the affidavit in question related to the conservatory orders application, which was overtaken by events. So it's really spent.
We reject the applications to cross-examine Speaker of the National Assembly and Speaker of the Senate. Those applications are dismissed, and we'll give full reasons in our judgment.
It is really not in my favor. It's prejudicial to my case if those affidavits remain on record and the authors cannot be cross-examined on them. They have made averments which are totally false and constitute perjury on this court. They have manufactured documents, and we want to put their feet to the fire.
Mr. Omtata, we have made a ruling.
I appreciate, my lord, but I think if
No,
we
no.
go in that direction, we are not serving justice. I need to be heard. I need a fair trial in this court. I need to cross-examine the Speaker of the Senate, who is my Speaker, and my junior.
Mr. Omtata, we have made a ruling, and thank you very much for your observations.
Alice Diana, Hope TV News Watch.